Let me get this straight. You blew up a building.
2 CIs and the CEO of 22andU.
2 competing federal agencies with the same mission.
I don't understand why those Fed a-holes are so darn mean.
To protect the public from the scourge of dangerous misinformation.
You know those bum idiots. This is all them. We had a solid case.
The word entrapment, not even in their vocabulary.
The explosives we provided were fake.
Sworn to a duty to always tell the truth.
We have no indication at this time that this was a deliberate act.
We're all being transferred.
To where?
The only place currently with openings. Alaska.
Good morning.
Welcome to the office, huh?
And we got the retro feel. You know, the funny about federal buildings, they're all different, but they're still somehow all the same.
Oh, good morning, Agent Walker. At the coffee station. We actually drew straws before he got here, and I won, so we get to work together.
Let's get started. Let's see if we can't stir something up.
Let's give it a minute. I like to warm up the truth muscles a little coffee beforehand.
Well, what do you want to do first?
What do we have for a surveillance van?
Oh, wow. I got a Ford Explorer. We don't have a surveillance van.
Do you put many cases here?
Cases?
Yeah, cases. We're the tip of the spear when it comes to protecting American democracy.
You really believe this? You really believe that people posting crap online is going to cause our country to crumble?
I think the work that we do is important.
We don't have a surveillance van.
Me and some people got one. We've never needed one.
We need a surveillance van. We need a big case or a CI who can lead us to a big case.
What do you need the van for?
Surveillance.
CIs, or confidential informants, are the lifeblood of any good law enforcement agency. Public posts on social media are one of the best ways to find CIs. Agents would never use coercion or take things out of context to try and persuade someone to become a confidential informant.
New Taylor Swift single is absolute fire. I'm just seeing a lot of incendiary and violent language here.
Agents always need to be on their toes and ready to make snap decisions.
Is there anything I can do for you guys? Actually, David, there is something you can do for us.
Chicky nuggies.
Chicken nuggies.
What?
Cheeseburger. Cheeseburger. McDonald's cheeseburger. Burger King.
Burger King cheeseburger.
Flame broiled.
And chicken nuggets.
Oh, baby, know you're gonna like it. I wanna be your beaver pilot. Said, honey, know you're gonna like it. I wanna be.
Awesome, right?
Is this a loner?
This thing's totally legit.
What is this? It's got windows!
Yo, yo, yo. We are live. We got a monster walking next to the camera. Well, actually a dog. Going to come over here, lay under the desk, cause trouble. Maybe try and squeeze through the little gap between my green screen and the thing. We're not going to do that, Thina. No. Welcome to the live stream. We are live, if you can't believe that. Live from the top of the world, Chugiak, Alaska. Yeah, that's it. Lay on the cord. Instead of laying on the bed in front of everybody, I'm just going to lay on the cord. That's the easy thing to do, is lay on the cord. Oh my goodness. What another just silly freaking day. The silliness just does not, it just doesn't get any better. And what I'm talking about silliness, talking about the decisions from the prosecutor, the decisions from the judge, the witnesses. We can't, as Emily said at one point, this is the second trial. This is trial number 2. You should not be having surprises, but every day we get another surprise. Surprise about this and a surprise about that. And it is crazy. All right. I did some more messing around with my mic last night because that's all I do is mess around with my mic. So let me know what you think. If it sounds good or if I sound like crap, you can let me know that too. Just say, hey, you sound like crap. I have my Jeff sweater on, so everybody say hi to Legal Vices. Enjoy your legal vices. I really, really miss Jeff. I never met the man, didn't know him, but he felt like a friend. So it is a shame. So I will wear this sweatshirt. I probably should get another one because I'll probably be wearing this one out. The light really reflects on it too. Oh, good. All right. So, all right, what do we got kicking here? Let's just get into it. First, on a completely different topic, but still in the courtroom. You guys remember the Murdaugh trial? Alex Murdaugh and the Murdaugh family was a huge family in South Carolina. South Carolina, right? Now I'm questioning myself. Was it South Carolina or North Carolina? Damn it. I'm going to have to look it up because I can't let myself. Alex Murdaugh State. South Carolina. I was correct. It was South Carolina. So Alex Murdaugh, a very prominent name, a very prominent attorney, took advantage of his clients, stole a bunch of money from them, and I guess in order to cover it up, he murdered his wife and his son. Now, the son he murdered was going to cost him a lot of money because he was involved in a boat wreck where he was driving a boat drunk and ended up killing a girl. And the family just had problems. So I don't know. Like, there were some decisions that were made in that trial that were questionable too from the state. Like, just basically they said one question was asked, hey, do you think that they have a good relationship? Talking about Alex Murdaugh. I don't know if it's Alex or Alec. I always hear Alex, whatever. The lawyer asked one question about the relationship between Alec and his wife. And the judge said that opened up all of the financial crimes that Alec was accused of. And that derailed the trial. And so for 2 weeks, they brought in witness after witness after witness, which said that this guy was a monster, that he took money from, and he was a jerk. He was one of the biggest scumbag attorneys there is. So they brought in witness after witness after witness that said, oh, he's the worst person ever. He took this money from these children. And he did. But still, that doesn't mean he's murderer. I don't know. I don't know if he did it or not. I think he's where he belongs. I think even the financial crimes, the crap he pulled on his clients and everything, he probably deserved a very, very, very long sentence in prison. But still, you've got to. I mean, we got to convict without a reasonable doubt. And man, juries just don't impress me. So anyway, I digress because I'm getting off track here. So he got convicted, but then this other story came out about the court clerk. Now, the court clerk was writing a book about the trial, or wanted to write a book about the trial. But in order, she thought, for the book to be successful, there had to be a conviction. So she took it upon herself to make sure, this is the accusation, but to make sure that the jury was on the conviction track. Now, did she come out and say, you have to convict this guy? No. But it seems like she made some statements that were prejudicial at the least, right? So she made some she made some presidential statements, she made some statements that were prejudicial. And then the other thing she did is she made up. Oh, there's one other story that just popped to mind. But she made up this Facebook post from one of the jurors' ex-husbands that supposedly this juror was at a bar talking about the case. And then, so she said there was this post on Facebook on the local gossip part of Facebook, and that this ex-husband of this person was making up this post. And then the post got deleted, and then he posted an apology that made it. And so she found this other post and she brought it in as proof, but it wasn't the actual right person. And the person who did the post was talking about something completely different, and it wasn't. So she made this stuff up whole cloth, found something that looked that she could kind of like cover her tracks with, took it to the judge, and this juror was kicked off the trial because of this dubious made up testimony from Peggy Hill, the court clerk. Because this juror was one of the main ones that was actually questioning the state, saying, I don't know, do they have enough proof here? And just not even saying it out loud, but was basically the one that showed the most skepticism, I guess. That it was perceived that she could possibly be showing skepticism as far as her thoughts were concerned. Oh, my headphones turned off again. And I reset it last night, but I guess I didn't save. I guess I didn't save this. What? But there's nowhere to save it. So it doesn't change. It changed when I got back in here today. It changed it back to the 10 minutes instead of 60 minutes that I wanted. But there's nowhere to actually say save my profile. I'm sure there is. I'm sure I'm just not mentioned. I'm sure I'm missing it somewhere, but Create folder for profiles. Import, export profiles. You click on the little 3 dots. You got rename, edit, duplicate, export. Nowhere does it say save my stupid profile. All right, sorry. I didn't want my headphones to turn off again. So, okay, well, that'll be good for the show. I guess I just got to reset that thing every time. All right, so this comes out after trial that she did all this stuff with the jury, that she did all this. And she gets brought up on ethics charges. And then I think there was some other, then she was brought in a court hearing, and she was put under oath, and she is now being charged with perjury for lying under oath. So she just keeps having a bad week. So let's take a look at this story here from Law and Crime.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you ever allow anyone from the press to view these exhibits? And then there was another thing that she did in her book. Oh, that's right. She oh, hang on. All right, let me go back to that. Sorry.
That testimony from Becky Hill, the clerk of court during
Peggy
Alec
Hill.
Murdaugh's double
Said
murder
Peggy
trial,
Hill.
has landed
Peggy.
her in jail.
Peggy Hill is Hank Hill's wife. Becky Hill is this chick. Peggy Hill is not.
Charged with
Peggy Hill is in Texas with Hank. Becky Hill is the person we're talking about.
perjury. And it's not the only charge Hill is facing. So could this lead to Alec Murdaugh getting a new trial? One of Murdaugh's attorneys is here. Welcome to Crime Fix. I'm Anjanette Levy. It's murdering his wife Maggie and son Paul.
All right, I don't want to go through a whole freaking thing.
Guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book, and part of that is because I think it was a guilty verdict.
Well, this is you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that
getting busted?
Is that correct?
It is, yes.
And you even have something where you say your eyes met with jurors and others at Moselle, and y'all have an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent. But at no time.
So she was writing a true and accurate depiction of what she went through during Alec Murdaugh's trial, but it wasn't actually a true and accurate depiction of what she went through. It was journalistic license all over the place. Okay. Exactly. Ma'am, what? What is going on here?
Read or try to read someone else's eyes, and that was just one of those gut feelings that I wrote in the book.
In the end, Justice Toll determined that anything Becky Hill said didn't influence the jury with the comments she made to them. But Murdoch's attorneys disagree, and they're appealing to South Carolina's Supreme Court. So why is Becky Hill facing criminal charges? Well, investigators with SLED say she committed perjury in another exchange with Justice Toll about sealed exhibits for Murdoch's trial.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
This is a law and crime legal alert. Did you know that children are being diagnosed with serious
Thank you. I muted it so I didn't crinkle the mic. Thank you. So this is kind of funny. This is her bond hearing. She's actually in the pokey. Hang on, let me share. Oh. Yes, it's only
good morning,
one.
everyone. I'm
one
Judge
side.
Fishburne. I'm going to conduct the bond hearing today. Want to welcome everyone.
This person's taking
we have
video of
Agent
it.
Trozewski, Agent Fitzgerald, Attorney Mr. Lewis, and the press. So welcome, everyone. Mrs. Hill, will you please state your full name for the record? Mary Rebecca Hill. Thank you. Do we have the they on the, okay, I see them. They're back there. I just want to make sure that the agents were there. All right. I'm going to go through the rights and responsibilities. I'll advise you of some information, and then at the end, we'll hear from the state and we'll hear from your attorney. And do you understand the charges and penalty? Yes, Your Honor. Okay. And I assume you're familiar with that location. And a bench warrant could be issued for your
This is kind of funny. So she's actually got arrested, had to go down to a bond hearing, and yeah. So will this lead to new charges? I don't think so. But they said she's facing some other charges too. So trying to see. Here we go. We have. Let's see what Good Morning America has to say.
The Alec Murdaugh saga. The former South Carolina county clerk has been charged with misconduct related to a role in Murdaugh's double murder trial. Our Eva Pilgrim is here with more on this story. Good morning again, Eva.
Good morning again, Michael. She was a fixture
Just a
in the
quick one.
courtroom
This is
through that
2 minutes
lengthy
and 44
6-week double
seconds.
murder trial. Now that former clerk is facing multiple charges in 2 different counties, all tied to her behavior in this case.
This morning, a major new twist in the Alec Murdaugh case. The county clerk who read off that guilty verdict when Murdaugh was convicted of murdering his wife and son. Guilty, guilty, guilty. Now facing her own charges. Becky Hill accused of taking
The lure of fame is intoxicating. Yeah, I mean, a court reporter is going to write a book and get, and she talked about after she was on cloud 9 when the verdict came in, and she was like talking to the jurors that's, here's your time in the spotlight, and we're going to New York City, and we're going to be interviewed on to the Today Show and Good Morning America, and they're going to put us up in the fancy hotels. I have to talk really slow when you do that. We are going to get to the fancy hotels in New York City. Fame is intoxicating. It will make you do stupid stuff. There was this, I can't remember what spurred it on today, but I was thinking too on the way home, like I'm Gen X. Gen X is appropriately named because, growing up, everything was X, and then X was short for extreme, right? We're the ones that invented the X games, the extreme games. Everything had to be on the next level. And then, but we didn't have the internet. We didn't have viral stuff. We had cable, right? And we had Jackass that come of age, in that time. And we had America's Funniest Home Videos with Bob Saget, people recording themselves and sending in their videos every week to Bob Saget so he could point and laugh and show off the funny people around. Oh, sorry, I was trying to adjust my thing. And everything had to be next level. Everything had to be extreme. Everything had to be, and then so if everything's extreme, how do you outdo it? Well, so now we're getting to a point where it's just extreme is just beyond. I mean, it's just beyond the bounds of human decency sometimes.
Taking photos during the trial of sealed crime scene images and sharing them.
Do you understand the charges and penalty? Yes, Your Honor.
Hill, who was praised for her work on the case,
I call her Becky Booth, that's her nickname,
went on to write a book and participate in a Netflix docuseries after the trial.
I had a feeling from our time together with the jury out at Moselle that it was not going to take our jury long to make the decision.
But beyond allegedly sharing sensitive evidence, she's also accused of lying to a judge about it, potential perjury, when questioned during a hearing for Murdaugh's appeal.
I do.
Murdaugh's team hopeful these new charges help their case.
I think bodes well for our appeal because
Dick Poon here. Dick Harpootlian, one of the lawyers for Murdaugh. I don't think it bodes well for their appeal. I think it's two separate issues. I think the perjury is not really going to change much because the perjury is about allowing the press to kind of look at some evidence photos. So I don't know that that's like super president. God, there's that word again. Prejudicial against Alec. I don't think it's that. So yeah, I mean, he can, and a good lawyer is going to use that argument all day and twice on Sunday, right? Like they're going to use that. They're going to use every argument they can possibly get. But I don't think it's going to work.
the state believes that they can prove beyond a reasonable doubt she lied in the proceeding before Judge Toll. If she lied about that, the question would be, what else did she lie about?
His legal team
I
saying
mean, it does. Yeah, it's good. He does put her credibility to on the edge.
they don't believe he got a fair trial.
Now, Alec, of course, has denied killing his wife and son. He's entitled to a fair trial, not one influenced by outside forces, but one in which evidence is presented and a jury bases their verdict on that evidence, not on something extraneous.
Murdaugh continuing to appeal his murder conviction and push for a new trial.
When it comes to seeing whether or not Becky Hill's allegations will affect Alec Murdaugh's case or new retrial or whatever it may be, it's not a matter of what level those charges are, but to what amount and what degree her actions might have affected Alec Murdaugh from not having a fair and impartial trial.
And to be clear here, no matter what happens with this appeal on the murder charges, Murdaugh will not be getting out of jail. He will remain behind bars for those financial crimes, which he already pleaded guilty to.
Got to keep that in
Yes.
mind. All right, Eva, as always.
So yeah, the financial crimes are going to keep dude in jail forever. So this chick though, oh my God, she's just next level bad. Just no way to put it any other way. So she wrote the book, she tampered with the jury, and then it turned out that Becky Hill, Colleton, that's right, Colleton. All right. My whole screen flashed before my eyes. Okay. Becky Hill, the Colleton County Clerk of Court, accused of jury tampering in the Alex Murdaugh double murder trial, has a new controversy on her hands. She's facing allegations of stealing from a draft of a BBC News article for her book. Allegations of plagiarism against Hill were made in an early Tuesday morning news release by Neil Gordon, a Georgia journalist who co-authored with Hill a book called Behind the Doors of Justice, which purported to be Hill's insider account of behind-the-scenes actions. Hill oversaw various aspects of the trial, had access to information the public didn't. Together with Hill, have decided to cease sales of the book. It just blindsided me. Hill's attorney, Will Lewis, and Justin Barrett released a statement Tuesday afternoon and said, in part, Becky Hill is deeply remorseful regarding an allegation of plagiarism that recently surfaced in her new book. She is deeply remorseful. She's not saying, I didn't do it. They're sorry that they did it. The pressure of developing additional content under tight time deadlines resulted in Miss Hill taking material written by BBC reporter Holly Hondrick and submitting it to her co-author Neil Gordon as if it was her own words. I mean, really? So, and I think even I think even how she got the article was, so BBC reporter Hondrick did not respond to an email query from the state asking her about Hill's admitted plagiarism. However, the February 20th, 23 email from Hondrick to Hill was apparently sent by mistake by Hondrick. About 3 hours later, on February 20th, Hondrick realized her mistake and wrote Hill, please disregard and delete the last email I sent you. I have an editor named Rebecca, and I confused the addresses when I sent it. So the author of the story for the BBC was trying to send her story to her editor at the BBC. Accidentally emailed Peggy Hill. I know it's Becky. I'm saying Peggy now. Accidentally sent this to her instead of her editor. Said, please delete this. And what does Becky Hill do? Oh, I'm going to use this for my book because I don't have the intelligence to actually write a book. I like the idea of being an author and writing a book, but God, it just takes so much work. And then she didn't even change the damn words. She just used oh my goodness. The lure of fame is very, very, like I said, intoxicating. It'll make you do weird stuff. It'll make you do things that you probably wouldn't do without that allure, that chance of being famous. Yes. Ooh, look at that. My lights seem a little weird today, so whatever. This shirt is really bright, and it's not that bright. I mean, it looks really reflective in these lights, but it's not. It's actually pretty muted material. It's just lighting. Lighting just does weird things. I don't know. Fun. All right, so that's the saga of Becky Hill. I don't even want to know. I mean, this freaking Karen Reed trial is so insane. So we finish up today with Marie Hartnett. That's how we start the morning. And I missed this because I was still asleep because it's 5 something in the morning and I'm not getting up every day at 5 or 5:30 to watch the start of this. I've gotten up at 6 a few times. So we get to the very end of her testimony.
If we could, Your Honor, have 147C.
Why not?
Try and get to the end of this here.
That was the
She makes a weird statement.
It's this one, yeah, exactly. Thank you, Your Honor. Do you recall Mr. Brennan asking you just moments ago, clear this?
That's correct.
The
honestly
of that, sure, was that question
from the record yesterday.
answering my question?
Okay, so end of testimony. This is the end of her recross
of what could have caused that hole in the sweatshirt. Did you?
No, I did not.
No further questions. Again, thank you for answering my question.
This is something you don't. I mean, this is another new thing in this trial that we've seen.
Ms. Hartnett, you are all set. I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that. Okay.
Being offered a.
I clicked the wrong button.
Do any analysis
Go
of
back
what
to that.
could
Sorry.
have caused that hole in the sweatshirt? Did you?
No, I did not.
No further questions. Again, thank you for answering my question.
Ms. Hartnett, you are all set. I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that. Okay. Do you recall which lawyer asked you the question? Yes, Mr. Leslie asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you at second?
Thank you.
Canoni is weird. She's just weird. You don't. A lot of people are speculating that it is the reflection, that she realized that it was a reflection because it's obvious that it was a reflection. But even if it's good for the defense, she is basically saying, I said something yesterday that was not correct. And so she knows she can't talk to the prosecutor. She knows she can't talk to the lawyers about the case while she's on the stand. It's not something that she can do. Right. And so at this point, you're stuck with, okay, how do I remedy this? And that's really hard to do. And so they go to sidebar, I guess. And I'm, like I said, I didn't actually see this,
That's
but I heard
awkward.
about it.
Want to correct something from yesterday? Don't know what. Don't know if it matters.
All right, so let's see. Not sure if Emily had anything to say about it, but at least we know where it was at. Okay, so we're right here. So let's see what Emily said about this. Shit. Damn it.
Yes.
Sorry, I'm stupid again.
Okay.
You got to remember that this should match this. Okay.
What?
Do you recall which lawyer asked
What?
to do that? You are all set.
All right,
I
we're
wanted
gonna-
to correct something from the
Oh.
record yesterday. I wasn't sure when was
What?
appropriate to do that. Okay.
What?
What?
Do you recall which lawyer asked you the question? Yes, Mr. Alessi asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you?
Alessi is like, Judge, stop. Let's not do this, please. Let's not go down this route.
The court's like, nope. And the I
All
bet
right,
she
so-
wants to correct the record.
Your Honor, are we going to proceed along with that?
So why don't I see you outside?
Thank you.
Oh, I bet she wants to correct the record. He didn't ask her about it. Oh boy. She just had some time to think about it. They're at sidebar. Yes, they are. We're gonna zoom. You guys have
going
some.
to let you step down because questions from both sides are completed.
Okay,
So
thank you.
you though.
Yep. And basically said there's no question right now. There's no question on the floor. There's no. Yes, you might have said something yesterday that was that you have thought about and didn't think was right yesterday, but then nope, you cannot correct the record. That's just not something
The court's
that
like,
you do.
nope. And the DA's like, nope. This witness said she'd like to correct something she said, and the questions are complete from both lawyers, and Brennan didn't ask her about it. Brennan didn't ask her about the mirror reflection. Redirect is when you get to ask those questions, and he didn't.
Yeah, no, exactly. It was just
she can only answer the questions that she's asked. She doesn't get to say, excuse me, I would like to correct the record. I imagine it has to do with the photos, but Brennan didn't ask, and neither
Right.
did Alessi.
They totally could have asked in redirect. He could have brought it up in redirect.
So that would be my guess. But the jury's going to be like,
could have.
but if she wants to correct her testimony, if some of her testimony is wrong, shouldn't we get to hear it? The witnesses can respond to questions. Oh boy. Let me just make a note and let's. Wow.
Now there was a big question as to whether they were going to call because they've got a expert medical person that they're going to bring on the stand to talk about the cause of death. So there was a big question. Now she was on the list, but Dr. Scortibello was a question mark as to whether they were going to call her or not. And they do.
Is Dr. Scortibello.
The coroner is next.
Yes. Thank you.
I'm sure the mods have been wrangling spoilers in the chat nonstop. It's about time they called the coroner. Dr. Scortibello is the coroner. I know everyone's excited. So as long as we can send out an app notification.
Pathology that was done at the Office of the Chief Medical Examiner for the City of New York. And then I went to work as a medical examiner.
Is there a certain type of doctor you are? Do you have a
Then,
cause of death
she goes through her qualifications and everything.
and manner of death the same or two different things?
They're two completely different things. And very often we will consult with them in determining cause and manner of death.
Are cause of death and manner of death the same or two different things?
They're two completely different things.
Can you explain to us what the difference is between the two of them?
Yes. Cause of death
I will be right
refers
back. We'll let this
to
go for a minute. I'm
the
gonna turn
disease or
speed
the
up a little
injury
bit.
that initiates a sequence of events that ultimately leads to someone's death.
She speaks pretty quick, so I'll go 1.25.
Disease or that
Give me 1 second.
injury
Listen to this.
can be a natural disease such as atherosclerosis or coronary artery disease, or it can be some sort of injury. The
Gunshot
manner
wound,
of death
stab.
has to do with the circumstances that led to the death.
Oh, no.
So there
That's the other
are 5 manners of death that we use in our practice. The most common one is actually natural. Natural means that the person's cause of
Heart
death,
attack,
the disease
cancer,
that killed them, was
age.
due to natural causes. And that would include
Oh,
heart
that sounded like a Zoom
disease,
call. That wasn't you. That was in court.
diabetes, cancer. All those are natural processes that take place in the body that lead to death. And so the manner of death is natural. If trauma or an injury is involved, then we have to decide then let me back up. If trauma or an injury is involved, then the manner of death is no longer natural. And therefore, it could be that the trauma was inflicted in an accidental manner, in which case the manner becomes accident. If it was
car
inflicted by
crashes,
another person
homicide.
with the intent to cause harm, then the manner becomes a homicide. And if the trauma, and when I say trauma, I should include both physical and chemical trauma. Chemical when it comes to intoxications due to drugs, etc. If the trauma was self-inflicted, then the manner of death is suicide. So we have natural, accident,
manner death,
homicide,
suicide.
Suicide.
Right. So basically, Brennan just asks her about.
The court is trying to remind all of you that you need to be. I don't think it is hugely detrimental to a case. Where it becomes problematic is more.
So they basically go through all of the things that she did, and to get to the point where she says, I don't know. Were you able to determine the cause of death? No, we think it was, I guess the manner of death. The cause of death is the skull fracture and the injury, the blunt force trauma to his head. And then the secondary cause, she said, was hypothermia. So
they seem pretty simple, but there are a lot of them.
Go along. Yes. When a case is called into
so
our
then they go through all of this stuff. There is no, for some reason on Emily's stream today, there is no there are no chapters on Emily's thing, and she's usually good about her people get chapters out. And then of course on Andrea went for 10 hours and 43 minutes, which means her transcript is delayed because that's a whole lot of transcript to write. The AI is only so fast. So we've got this one with no transcript, and then this. So we just, basically there's just go through the reasons for
what we call a compound injury and abraded laceration.
We'll turn in a few moments to your autopsy observations about the inside of Mr. O'Keefe's skull. But first, I want
Look at the base of the skull. I noted that there were multiple fractures that appeared to be originating from the area of the laceration, or what would correspond to the area of the laceration.
So, yeah, this is all pretty. He died from a head wound. So then Andrea goes to the buffer zone amendment. So there was an amendment today.
Him for this cross too. Very excited about that. Let's go ahead and take a minute to go over and look at what has happened here with the buffer zone.
I'm going to speed this up so we can
buffer
listen
zone.
to it.
We got the supplemental order regarding the buffer zone is out. So
this is from Norfolk. This is actually the Norfolk County. This is Judge Canoni.
Oh, let me make my
making
it's a
the
little small. Oops.
buffer
A
zone,
little smaller here so we can read it.
making amendments to the buffer zone.
Here's what they've done. They have
So
supplemented
we'll see what
to simplify any potential First Amendment issues related to the buffer zone restrictions. First, for all of the reasons cited in support of prior orders and based upon the parameters of this dispute as narrowed and described in the decision, all orders of this court remain in place insofar as they apply to courthouse property. We're going to go back and look at the opinion if we get a chance, just to see exactly what they had held and what they had called for in terms of modifications of this order. But essentially, there was not really a dispute about the court's ability to monitor its own property and make decisions about that.
Right.
Second, prior orders remain in place as applied to pathways, including public sidewalks and roads through which and at which times trial participants enter and exit the courthouse. So pathways through which they enter, but at which times, this is some strange language. I'm not sure because it's grammatically a little bit off. At which times, but you're not referencing a time. Unless the prior order says like only when they're entering and exiting. Does that mean you can do it at other times? Not entirely clear to me from this language. Third, noisy protests, including those using amplified sound, honking horns, or loud screaming and yelling that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of his or her duties are prohibited within the buffer zone. Noisy protests that are intended to interfere with the administration of justice. We're going to talk about that.
What does that even mean? What does that even mean?
Written or
that's like that. What are you even saying there? Like
graphic materials that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of their duties are prohibited within the buffer zone. And fifth, any person whose activity...
That's messed up too, is that you can't do this. This is not something that is legal. This still is not a legal order.
By an officer enforcing this order may request a review by a judge of the superior court, which request shall be heard as expeditiously as possible.
Now, some people were saying that, oh, you get to go in front of a judge immediately. You get to go, right then to a judge. Well, I doubt that. As expeditiously as possible does not mean you get to go right away to a judge.
Off-site demonstrations on public property in areas and at times that do not interfere with trial participants' entrance into or exit from the courthouse, and that do not interfere with the orderly administration of justice,
turn off your
and
damn
that
sirens.
are not intended to influence any trial participants in the discharge of their duties are specifically outside the scope of the buffer zone restrictions. So that is the new order. So let me ask you guys this. Having now read this order, do you
it doesn't even
feel
mean
that you know whether you can wear a Free Karen Reed t-shirt within the buffer zone?
Correct. Yeah, exactly.
Do you feel that that is clear?
No.
From this order? Can you wear a Free Karen Reed shirt inside the buffer zone?
Nope. Yes, no, I don't know. Maybe.
Is that clear? See, here's the problem with it. And this problem, from my perspective, it's a problem with enforcement. It's a problem with is it clear enough to guide law enforcement about how to make specific decisions and so forth? How are we applying this rule with respect to any particular people? The problem that I see is with the intention. The order as it's written, this new modification makes it clear you can wear a Free Karen Reed t-shirt within the buffer zone as long as you don't intend to interfere with the administration of justice or influence any judge, juror, witness, or court officer in the discharge of their duties. As long as you don't intend for any of these improper things to happen, you can wear the Free Karen Reed t-shirt inside the buffer zone. Likewise, you can yell, shout, honk your horn, as long as you're not intending to interfere with the administration of justice or influence any judge, juror, etc. So it's the intent that has now been made the limiting factor. And that derives, let me get the order up here. That derives very specifically from what the First Circuit found. I don't know if you guys can see that. Looks like it's okay. So I'm just going to walk through this a little bit quickly to get the point. So we had these, we had the order that didn't allow vehicles honking, extended the buffer zone, prevent the interruptions and distractions, because people in the courthouse could hear the voices and the horns and so forth.
Which is, so some of the jurors said that was horse crap. They didn't actually hear the thing. There's one former juror that keeps going on shows and going on court TV and stuff. And he just talks a bunch of crap. He's just this little goofball.
So then people sought to demonstrate. They challenged the order.
Definitely on the convict side.
Set out the legal standard. You got to show reasonable likelihood of success on the merits. So first off, they conceded they don't challenge the order as applied to courthouse property. That's why the first provision, everything dealing with the courthouse property, remains in effect. Plaintiffs aren't challenging that. Doesn't seem to be any real argument that the court lacks authority to do that. There is quite a bit of maintain order and decorum in separate room. Wearing a Justice for John O'Keefe or a Free Karen Reed t-shirt. It's not appropriate in that forum. So nothing challenged applied to the courthouse property. Nothing challenged with respect to the pathways through which trial and what restrictive argument in favor of noisy protest. So they don't dispute some demonstration or beyond courthouse grounds, at least some demonstration related conduct is permissible, such as picketing, intimidation, disruption of court proceedings, and public disturbances. So ultimately, the nature of the challenge is that plaintiffs want to engage in quiet off-site demonstrations on public property in areas and at times that do not interfere with entrance and exit, don't interfere with the administration of justice, won't influence any trial participants. So,
yeah, I mean, you want to be out there and showing your support. It's completely understandable.
I don't know.
Skip forward this here.
That we are. I just don't know. Trust the cops to do that. Are we going to trust the cops to do that? To make those fine distinctions?
We saw last night.
I don't know.
We saw exactly last night what the cops are actually going to do.
I don't know that we are.
Cops are not going to be your friend on this.
Don't know that that's a realistic expectation in light of the realities that
are
be like,
look at that thing you're wearing. You're wearing.
If they do, and they knock it off, okay, you're perfectly allowed to wear a Free Karen Reed t-shirt within inside the buffer zone. You just can't. You can't wear a what was it? Criminals Control Norfolk County. You can't. Yeah, if you can't wear that, you can't wear a free do something that demonstrates.
So we'll see. It's so ridiculous. All right, so then we get the toxicology.
After your autopsy and observations of Mr. O'Keefe's body, inevitably, did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes, the cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was there a primary cause of death in your opinion?
The blunt impact injuries of head.
Yes.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, 6.
Force injuries were conducting your autopsy, or even at the end of Mr. O'Keefe's death, to a reasonable degree of medical certainty?
No, I was not.
All right, let's go back
here. Were you
here.
able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yeah.
Brennan's voice just drives me crazy. His voice is so ridiculous. It's just horrible. It's He's got a ridiculous, he's got the Massachusetts accent, but he's also got this. I don't know if it's just a whiny component or what it is about the nature and tenor and everything about his voice, but it's grating.
Yes.
It just grates on. And it's probably the content. Maybe it's just the content that and his voice just adds to the maddening of the content that this guy spews.
It's the death certificate.
Did you do so in this case?
Yes.
When you file a death certificate.
Okay, so basically she said he died because of blunt force, a blunt trauma to the head, but I don't know the manner of it. When she talked earlier about manner, was it a homicide? Was it an accident? Was it? She does not know the manner of death. So now we get to
include your ultimate conclusions regarding cause and manner of.
Now we get to Leslie cross-examination.
Quickly, but if you could just check me on this, the 5 main categories of manner of death. So you talk about natural causes, correct?
Yes.
You talk about.
Then they go back to it.
Surgeons
and he basically, now he does do something interesting here. Is he goes through he talks about how forensic pathologists are they are the ones that should be doing death investigations. And so he goes through, that sniveling little, it's snivelly, it's finky, those are all words that describe that voice. Nope, they are. So he goes through, and there's a reason for this. So let me see if I can go back.
Would you want a neurologist to conduct a death investigation?
So he goes through how forensic pathologists are the ones that should be doing death investigations because of their training, what they've been through. And so he goes through a bunch of different types of doctors.
Would you want a neurologist to conduct a death investigation?
Personally, or are you asking me that? No, I don't think every physician has their specialty and their training, and forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
Going back into the many qualities of a medical examiner and attributes, they also have to have the ability to form opinions based upon all the available information using the scientific method along with sound reasoning. Is that a fair statement?
Yes.
And you're familiar with the term scientific method?
Yes.
And is it fair to say that the science...
So I was trying to find... Basically, Brennan has brought in a new here we go. Let's see if I can blow this up. I guess, is it on Sleuthy's thing? Hang on. Let me go. Bear with me here. I bet you it's on Sleuthy's spreadsheet. Oh my God, I can't think. Now, is it in my, now where did I put that spreadsheet? My goodness. Timeline. Yes. Got it here. Okay, so witness lists. All right. Let me blow this up. Let me go ahead and share the screen too. Okay, so this is Sleuthy's timeline and spreadsheet. And so she has all of these cool tabs, including the witness list. So we have Dr. Scoribello somewhere on here. Yep, Dr. Irene Scoribello. And then we had Dr. Renee Stonebridge. Oh, what's this? Dr. Isaac Wolf, Miami Neuroscience Center. So let's go back to the question now.
Pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
So Brennan is going to bring in Dr. Isaac Wolf from the Miami Neuroscience Center, a neurosurgeon, and unless he just got the prosecution's main forensic pathologist to say, no, I don't think it's appropriate for a neurosurgeon to do a death investigation or an autopsy. That's hilarious. That's just, I mean, that is freaking hilarious that he was able to get that out of the prosecution's own witness. Like, no, it's not. That is not something I would want to do. And in fact, I think was it the beginning when she kind of got everybody to laugh. She kind of told a joke. Let's go back a little bit more because I think they were asking about a cardiologist.
Of those principles. So in order to conduct a proper medical legal investigation, the medical examiner has to have certain qualities, if you will. Is one of them being well-grounded in general medical knowledge?
Yes.
Is another appropriate? Wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is that correct?
I would not want them to be conducting an autopsy, correct?
Right. Would you want a neurologist to conduct a death investigation?
After this, because I know she got a laugh out of everybody.
Personally, or are you asking me that? No, I don't think every physician has their specialty and their training. And forensic pathologists are trained to perform autopsies, and cardiac surgeons are performing.
That was it, because she kind of laughed there. She's like, me personally?
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
Okay, maybe it was just her laughing at her own thing.
They also have to, using the term scientific method.
Then they go in the scientific method. So then he's basically trying to pin her down on some things, and they get into some really deep medical.
You had performed all of the medical investigation and analysis.
Autopsy, the information that was provided to me based on the circumstances and where the body was found.
I don't know how much it's going to translate to the jury, but it's definitely putting
state what you phrase that as, because I want to use your phraseology.
Blunt impact injuries of the head.
So blunt impact injuries of the head. Is it fair to say that that was a very severe injury?
It was a severe injury, correct.
And would Mr. O'Keefe had been rendered unconscious nearly instantaneously with death following shortly thereafter?
It's very possible, yes.
Is it more than possible? Is it probable that that's what would have occurred?
I can't tell you how quickly he would have been rendered unconscious, but at some point after that injury, yes, he would have been rendered unconscious.
Is it possible he could have been rendered unconscious immediately?
So she's answered it this way. I think you need another person for that. Let's move on from that, Mr. Leslie.
You made your own determination of the cause of death, correct?
Yes, that's my job.
Understood. And what I want to do is pursue the basis of your determination. So you used the phrase brain, right? And that's your vision. Did you carry out any
It seems like they get something.
I don't know.
Gets into the sidebar here pretty quickly.
The pattern, other internal injury.
If we could please, just going to check to as an evidence.
Okay.
Evidence.
Oh, it's in evidence?
Yeah, I just wanted to make sure if there was any.
Oh, she's really not letting him use this witness to kind of vet and preview the other witnesses.
Yep.
Seems fair to me to be asking if she got new information after the fact.
Sounds like mom's home.
You do, in fact, have the ability to change.
Yep. So then they get
and
into.
What I want to do is to go over what is depicted there, and I'd like to start with and an impact ahead on a ground with.
So then they kind of talk about hello Jim, how are you? Welcome. So they talk a bit about the head injury, and I think this kind of previews what the defense is going to bring in, because they question about if you fall backwards and land on your head.
When I measure the injury, I use the ruler to.
You expect to see
and if you could
the kind of injury that he got.
Attention to what I will refer to, and you use your own term.
Or would you see more of a spiral injury? And so that might be a little foreshadowing of what they're saying. And she said, no, you could.
Correct.
And just so we get all that's depicted on this, you referred to earlier above that, the red area. And is that?
Let me just see if I can find it on Emily's, because I do have the transcript on that. So I believe it was spiral that he used. No, maybe not. Gosh darn it. All right. We're getting close here with Andrea. So
abrasion?
Just keep
yes. And do you also denote to the left almost like a J type item?
That's part of the abrasion.
Actually, I think that might have been going on earlier.
You didn't make a separate note of what appears to be a J, and it might be easier to see it in the screen over there. It's your conclusion.
J, huh?
So basically, he kind of questioned about the type of injury that you would get by falling backwards and hitting your head on the ground. And she said, well, no, I could expect this type of injury. So the feeling later on in their expert is going to say, no, I think it could be a.
And does that therefore mean that
I think it could be.
You don't know who they are, that they are law enforcement? Are you able to determine that?
Correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who they are.
I don't know who they are specifically and what their actual position was.
But they were with law enforcement.
I believe.
Okay. Important thing here. The other day, Trooper Connor Keefe got on the stand and said, I was the only person that attended the autopsy from the troopers. So we look at this picture here.
And that to you, please. You can take a look at it. When you've had a fair opportunity to look at it, you just look back up and I'll proceed at that time.
Yes, I recognize the picture. Well, I've never seen this picture before, but I know what it's depicting.
Thank you.
New stuff, new stuff to come out in this trial. It blows the mind that we're into the second trial.
Standing in a
We get all
morgue
this new
setting,
stuff.
which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Thank you, Mr. Wolf. And if you could please.
And what's I think the part about when he's asking about, do you think a neurosurgeon should be doing an autopsy? And she says, no, absolutely not. This isn't in a vacuum. She knows that they're going to call somebody to try and basically supersede what she's saying, that you can tell what the manner of death was. She knows that they're going to try and throw her under the bus. And so she's pretty smart to say, no, I don't think a neurosurgeon would actually be able to do that.
Zoom in on the two individuals in that picture.
So Trooper Connor Keefe got on the stand the other day and said, I was the only one that attended the autopsy.
Dr. Scorty Bellows.
Now, the name of this photo just so happens to be, and of course it's not going to pull up for me, Proctor and Keefe. Now, the defense does get to name the photos, but if the jury sees that, and of course it does not get objected to, right? The Proctor. Brennan does not object to the name.
You recognize.
He probably could have objected to the name and gotten it removed, at least the name of the photo.
Any of the individuals in that picture?
To be perfectly honest, no, I don't.
Looks like Connor Keefe.
With regard to the person on the right, do you recognize that person?
No, I don't.
And you said you recognize the setting, correct?
Yes.
And if I heard you correctly, you said this is the Cape Cod facility?
It appears to be, correct.
Right. So you testified earlier, if I recall correctly, that the autopsy performed at the Cape Cod facility of the Office of the Chief Medical Examiner.
Yes, it was.
And you're normally in, as I recall, Westfield, in an office that covers Western Massachusetts. It's Westfield?
Correct.
But you were at the Cape Cod facility, as I understand it, because there was a staff shortage and you had to travel down to Cape Cod for this. Is this correct?
Correct.
So you were at your normal home-based sort of facility. This is a facility that you went to for this autopsy, correct?
For this autopsy and multiple others, yes.
Yes. And you were covering a staff.
Why would they say he was the only one that went to the autopsy, though? That's what why? Of all the things that could be, of all the things that you've done so far, and you keep compounding on this, you keep compounding your lies. It's like
shortage.
Oh my Lord! Come on.
To Cape Cod, correct?
Correct.
And
it's insane.
What's depicted in this picture are two individuals. For two individuals to be present, is there a protocol that they had to follow to be present for that?
There is a epidemic of baldness going around the MSP. I mean, it seems like you can't be a trooper unless you're bald.
Like a sign-in or an authorization?
Yes, there is a
some of them got the little
sheet
tight
that individuals have to put their name and their shield number
fade haircuts.
and before they can come into the autopsy room.
There's an important right there.
Yes, there is a sign-in sheet that individuals have to put their name and their shield number and before they can come into the autopsy room.
So they have to put a shield number down, correct? You mentioned a shield number.
Yes.
And does that therefore mean that even though you don't know who they are, that they are with law enforcement? Are you able to determine that?
Correct. I believe they were with law enforcement.
So those two individuals were with law enforcement, but you don't know who they are.
I don't know who they are specifically and what their actual position was.
But they were with law enforcement.
I believe If my memory serves me right,
Yep.
there was a person from crime scene
You are
investigation
correct.
and
Yep.
someone from state
Oh, I know.
police. But I'm working on a 2+ year memory.
Fair. That's fair. That's fair. I'm not going to ask
All
you
right,
more
so we
questions.
get this. So we get testimony the other day. Nope. I was the only one. I went to the autopsy by myself. And then I actually want to see, what did Emily say about this? Can we find that? Make sure I hit the switch tab button. All right, let me recognize. Okay. Here, one moment. Okay, so yeah, here
Photo.
we are.
She's at a morgue setting. Oh. But if it's the morgue, it might not be during the autopsy. That's fair. That's why I'm backing it up. If it's the morgue, it might not be during the autopsy, but we'll see.
May I, Your Honor?
Yes.
Thank you. Dr. Squirty-Bello, if I can hand that to you, please. You can take a...
We'll see if there's
Yes,
a
I
reasonable
recognize the
explanation or
picture.
not.
Well, I've never seen this picture before, but I know what it's depicting.
All right, and if
so
you could
now we
please
get it up on the
Very,
screen.
zoom in on
very
the two individuals
interesting.
in that picture. Dr. Squirty-Bello, do you recognize any of the individuals in that picture?
I do.
To be perfectly honest,
She does.
no, I don't.
With regard to the
completely fair.
person on the right, do you recognize that person?
No, I don't.
The jury doesn't know what Proctor looks like, by the way. Not from this trial.
And you said you recognize the setting, correct?
Yes.
And you, if I heard you correctly, you said this is the Cape Cod facility?
It appears
said
to be.
morgue.
Right.
Right. So
I'm not surprised that she doesn't recognize who's in that photo.
and what's depicted
And
in
she's
this
not gonna
picture
guess under oath.
are two individuals.
Yep.
If you're new to this trial, we did not see that photo before, and there was a discovery dump or a turnover of information between trials from the federal investigation as well. So could that photo have come from there? Yes, it could have.
Oh, that's a good point. This photo could have come from the feds.
Do I know that for certain? No, I don't. I do not know that for certain. Could that be a reason that we did not see it in the first trial? Yes, it could be. So
Yeah, if the feds got a hold of that somehow and it didn't get oh man, just so many moves and shaking and oh my goodness. All right, so then we go on.
Did I hear that
We
correctly?
just
Yes.
Can there
basically
be hypothermic changes without a cause of death being hypothermia?
Yes, of course.
So you can have
so now we get into a little bit of
scenarios
hypothermia.
that you look at, if any, for the cause or manner of death of Mr. O'Keefe.
I'll allow that question. What, if any?
At the time
She allows a question because it's a what if any question. Oh my
of the autopsy,
this woman.
I documented injuries
I just like
and signs of hypothermia. I was provided with a set of circumstances. And at
basically
the
said, what?
end of the investigation, or at the end of my timeline,
Wow.
I concluded on the cause, but I did not conclude, or I did not determine a manner.
We know.
The manner.
So yeah, I mean it's just kind of all right. So then we get just I mean it's just more argument
where the back
about
of the head hits flat frozen ground. Would you expect
There we
that?
go.
Specifically, laceration from that type of a fall, not just a general
This
fall
is
backwards,
important, too.
but specifically a fall backwards where the back of the head hits flat frozen ground. Would you expect that?
I could, yes.
And under what circumstances could a laceration like that and an abrasion, all of it together, what circumstances could cause that type from a fall backwards on flat frozen ground?
Well, the laceration is due to the blunt impact, and so is the abrasion. The abrasion is friction. So depending on the type of surface, you mentioned flat frozen ground, it's quite possible to have an injury as the one depicted. There's nothing inconsistent with this injury, and a fall on someone's on the back of the head with a blunt surface.
Is there? Are you familiar with the phrase?
That right there was probably not a win for the defense, to be honest. That was probably, you notice he kind of moves on, but yeah, I don't
pattern
know
recognition
that was a win
in medicine.
Yes.
And
then we move on to pattern recognition. Then we go to lunch. And Cat is here. So, yes, we get lunch. Then we come back. Then cross-examination resumes.
Thermia analysis, is that correct?
We get in the
The histopathology was done.
Then we go into the stomach part where I guess they showed some autopsy photos of the stomach. Then they showed an autopsy photo of like from a textbook or something of how something should have looked. And then one of the jurors said, "Hey, I kind of want to go on a break, please." So
gastric mucosa.
Okay,
Start with that.
What number?
I don't know. He gave her a big stack of things. Brennan did.
Ooh, all
Big stack
right.
of
We
photos.
got
So these are autopsy photos, right?
nice. Well, thank you. I just got a text from my friend.
Okay, so that was the one I was referring to.
My
that we did
mic
at
saying
sidebar, not in
it
open
was
court.
good. I
Okay.
finally found the right microphone, so I appreciate the heads up there. And yes, that's good. I'm glad I've settled on this mic. I've settled on how I've got it set up, and I'm actually running it. I found out through. I'm going to get geeky here for a second. So the software that I run is called Voice Meter, and it's got a gate and a compressor and some other sound stuff. Well, I realized, it had a dial that you could turn up and down, and I never liked how that worked. And then I was messing around with it yesterday, and I right-clicked on one of the things, and I realized, oh my goodness, I have complete control of this thing. And I don't know if I can share it or not. Let's see. Oh, yeah. Okay. This is my sound controller. And this over here just says compressor and gate. And oh, this is interesting here. I'll show you this in a minute. So denoiser, right? And then you can also run an effects chain. Well, I had tried to run this effects chain with this other compressor. But then I realized yesterday, I can click here and I could get complete control of my gate and my compressor, and I can change all these different settings. And I'm like, I had no idea this is here. Now, I could have known that this was there because I could have read the damn instructions. If you read the instruction book, you usually find out interesting things like this, that if you right click on the gain or the compressor button, that you can bring up the actual controls of things. Who would have thought? But then there's also a noise remover, but then a voice modeler. What is a voice modeler?
This is a voice modeler. So it does things like this.
And you can
really change the pitch of your voice, as you can tell. Now, I can also just turn this off.
And not do that. And set it all back to 0. But yeah, so it's got all these cool things that I just finally just found, and I'm blown away. Yeah, not reading the instruction manual exactly. So, yeah, so I had fun. So this is a very powerful piece of software for PCs. So, all right, that's my yakking for the.
Yes.
It's all identification.
All right. So.
All right.
All right.
All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Lessie?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
So yeah, oh yeah, it gets
Yes.
graphic. Oh, you can see it right there too. Look at that.
May I, Your Honor?
Yes.
This is graphic, huh?
Dr. Strubello, I'm handing you.
I don't know that they meant to put that on the TV. As you can see, there's the picture right there. There's the graphic picture.
164.
Right there, you can see that is some stomach stuff going on.
May I, Your Honor?
Yes.
Oh yeah, we got stomach stuff.
64.
All right.
May I, Your Honor?
Right there. Now, can't really see that. But you can see that that's kind of stomach stuff.
This is graphic, huh?
Dr. Strubello, I'm handing court's permission. Mr. Wolk, if you could publish 164.
So
I mean, you can kind of see it.
basically what he's trying to get at is the
Dr. Scordi-Bello,
also
do you recognize 164
John's stomach.
Well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface is the mucosa. That's the lining of the stomach. And you had used the word rugae before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right. So those are what you just showed. There's darker areas. There's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct?
Wisniewski's was correct.
Well, that
Okay,
is
so
what
he says
you refer to
Wisniewski's right
as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't.
So they got into this whole argument about Wisniewski's.
Use Wisniewski's in.
I have a friend named Wisniewski. He's a pretty good friend. I haven't talked to him in a little bit, but I wonder if he knows that his last name is a type of stomach hemorrhage.
In your report,
I'll have to ask
correct?
next time I talk to him.
Correct.
Okay. So what I'd like to do now is to, if I may approach, Your Honor, to the chalk.
He's going to time of death, guys. He's challenging hypothermia. How long? That's why I think
let's
this
see
matters.
what she answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Doctor, and see if you can identify.
Stomach, again, the mucosa with hemorrhage.
Oh, for the siren.
Yes.
Sirens.
I think this matters.
Oh,
yes.
Time. How long was John outside?
All right.
Oh, for the siren.
So the fire engine comes by, but this right here.
They're going to the time. How long was John outside? That's why I think this matters.
Yes. Yes.
Guess we're taking a break for the jury.
See, it sounds like somebody in the jury got kind of hurriedly rushed away. So, not everybody is likes this kind of stuff or can tolerate this kind of stuff. I mean, I can tolerate it. I don't like it. I don't enjoy it. I don't, and you can ask my wife. You can ask her all about all the times that, like when chickens need to be done or sheep need to be done or whatever. I am not the one. I am not the one. Yep. Oh yeah. Ask him if he gets paid. If he's the guy. Yeah. Oh my goodness. Yeah, the Wisniewski thing. So we argue about the Wisniewskis for a while. Take a little break. Come back.
You have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach.
Yes.
So now they're making a argument that, and this is another thing. This is kind of foreshadowing the defense's case in chief, that they're going to say that the hypothermia was not a cause of death, and this is one of the reasons.
You have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach.
Yes.
And what percentage of the, and I'm trying to avoid putting it up again. So what percentage?
So he's trying to avoid putting the picture up again, because I guess probably one of the jurors is like, not going to like that. You're not going to make friends with the juries if you make them sick.
Of the gastric mucosa
Jurors
of
are
Mr.
probably
O'Keefe,
not going to
which you
enjoy that.
estimate
So
is taken up by the ulcers that you have identified.
I would say somewhere between 10 and 15%.
Just 10 and 15%.
So, okay, so is this strong evidence? Could be. What are some of the arguments you could make? If somebody is struck in the head and they pass away fairly quickly, the stomach is not going to be able to produce those Wisniewski ulcers or hemorrhages, whatever they are. So that is an argument that can be made against this. We'll see how, that was just the first thing that popped in my mind. Okay, maybe there was no time to do that.
Thank you.
So we will see.
Now, if we could
Repeated it back.
look to the issue of continuing with hypothermia. Let's look to frostbite.
Frostbite,
Okay,
there it is.
so-
We saw it coming.
You note any evidence of frostbite?
So then they get into the frostbite. Okay, so there's no frostbite on there. So now we
There was
get
that
into the,
Theory. Be able to the dump. She doesn't let him ask that question.
Your Honor, Mr.
Gas duration is a blunt force injury. So let him ask
now
that.
we're going to get into the last bit here is the
166, and
arm.
Your Honor, may Mr. Wolf publish?
Yes.
Thank you.
This is the arm picture.
Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe? You would
Oh, okay, that's
classify
right.
that
They
as
were
a
talking
scrape.
about the nose and that she didn't really.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
So that basically they're showing some of the abrasions
Could
that
it
were
be
on his
caused by a
head,
punch?
on his face.
Friction can cause it.
Testimony, you
They're
talk
saying-
about injuries to the right arm of Mr. O'Keefe.
Now we get
You
into
recall
the
that?
arm of Mr.
You,
O'Keefe.
in your autopsy of those wounds to Mr. O'Keefe's right arm.
Anyone mentioned a dog to you? Since
With
then?
Your Honor's permission, I would like to.
Hypothetically, you ever consider a dog?
This is one of the things that in my write up today is just, it blows me away. He is not allowed to ask about about other things that could have caused this injury. He gets objected to and sustained. All right. So let's just watch here. And then maybe we'll go over and check out.
Permission, have it published. Those two on the screen. Am I correct that you noted these injuries and these wounds to Mr. O'Keefe in your autopsy report?
Yes.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on her answer to the last question, ask something else.
I'm sorry, continue.
Ask another question. Sustain.
She's sustained because she answered that she couldn't tell what they were caused by. So Bev sustains the objections on whether they could have been caused by a dog bite. This is important.
Ask another question.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So can you answer that, Doctor?
I cannot.
So she says, I cannot tell you. You cannot answer that question. So that's the
Do you
end,
recall
basically,
discussing
of
it all on your
dog
direct
bite.
examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
Clothing?
He did not have any clothing, was packaged.
Okay, so we get to Brennan.
Explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that question.
Do you remember Attorney Alisi read you that part of your statement?
Yes,
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
So
to complete your statement, you said, but in the whole context, I believe
Brennan starts reading her statement to the grand
that
jury.
those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Sustain.
Listen to this guy's tone. He is basically going to start yelling at again. He's done this before, but he's going to start yelling at his own witness. And he's going to start with this really harsh tone. So now we get this, that not only that accent and not only that, what do you call it? That rat fink. I gotta go back up and find your thing here. Yeah, that just that voice, that sniveling little fink voice. And it gets so much worse right here. It gets so bad.
And you can show her the statement.
Impeach her. So we should
The rest,
Yes.
could you share with us?
Oh, turn the paper over.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context, which was presented to me. So in the case of
This isn't even helpful.
This particular case, those hemorrhages in the context of a body found in the snow.
Individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
So here we go.
You said that there would be a log identifying names.
It would be a log, yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Lesson.
So Britain's got a log of who signed in to the autopsy. Let's see what the names that they put on this log.
We just need a moment to take a look.
I can move on and we'll come back to it, Your Honor. You mentioned
I
that
guess they're going to come back to
Mr.
that.
O'Keefe's
So
body temperature was a little under 81 degrees when he was brought normal. Fair to say there was over an 18-degree drop in his body temperature? As the medical examiner.
So let's switch over here to Emily because I want to get this. So let's go to the log thing.
I believe one person was Mr. Keefe and the other one was.
So we go back to the log. Okay.
She also
So
had conversations.
this is the log.
Did you hear what he just said? Remember we were talking about the log? I don't know if this is the actual log, but he asked her to take a look at it.
These guys are complete scumbags.
Yes.
Who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Wait, yeah, Emily.
She said
she's
Mr.
onto
Keefe
it.
and Mr. Connor, but wasn't the trooper's name Connor Keefe?
Yes, it was, Emily.
Isn't
it sure was?
that the one name? I'm going to back that up and let her answer again.
Yep.
Yes.
Who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Mr. Keefe and Mr. Connor. His name is Connor Keefe. What is happening?
Are you part of the criminal investigation team?
That's a mess.
No, I am not.
Yeah, it's
Did you go to the
ridiculous.
scene and evaluate any?
Y'all, I'm
All
not
right,
going
I'll
to
be
cover
right
it
back.
yet,
We'll let this
'cause that is a
run.
fuse
I'll
that
be
has
right
been
back.
lit. When it
Give me
goes
1
boom, we will go to Code Red, because I don't know if he wrote his name on 2 separate lines. There's more. There's just more. We don't know, but there's just more. So we will see.
Any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical
That's a lot of
examiner
questions.
in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You would never. Oh, let me ask you.
What is happening?
You
Real
submitted
interested to hear
the
recalls.
death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or
Is
filed
it-
your death certificate.
Is it relevant then?
Were you informed or were you aware that before you filed your death certificate,
His voice just is
there was
like,
information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that,
So now-
that the defendant
now he gets to bring in all these different people. He gets to opine and lead this witness. This is all ridiculous. This is all leading questions, right? This is completely leading questions. This is just him getting to read off all of these statements, supposedly.
I'm going to allow it.
that the defendant said,
She's going to allow.
I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin?
See, Brennan, what's going to be really interesting about this line of questioning is that it seems that she considered these things and did not find it persuasive. So asking her, did you know I hit him? And she's like, I was aware. Okay, well, it didn't change her mind about the undetermined. So if you list out your whole case for the coroner, who I imagine the jury likes, and you list it all out and say, were you aware of all of this? And she says, yes, I was aware of all of this. And then still came with the undetermined finding.
Right, exactly. I still didn't.
It's not
still
going to
didn't-
help. It's not
Right.
going to help because she's aware.
Who provided
Bold
information that the
strategy,
defendant said,
Brennan.
I hit him.
Let's see how it works out for you.
Were you aware of statements made by the defendant, to Ms. McCabe, that she said, may have I hit him? Did I hit him?
Objection, Army, approach, please.
Oh no, Alessi, let him pick up that shovel and keep digging. However, I think Brennan just misstated testimony,
Yeah,
but let him pick up
exactly.
that shovel and just keep, I don't think that's going to go well for him. I do think he misstated testimony. Twice, hit perfectly. Not kinda, not sorta, like dead ass verbatim.
Had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe.
And then she just lets this go. That's the most frustrating, ridiculous thing is she lets this go.
Massachusetts State Police spoke to other witnesses about their observations that night.
And just on and on and on and on and on and on.
Mate, about statements made by the defendant to him.
I
is dead.
Carrie Roberts. She gets to go to Carrie
And the question of
Roberts.
did I hit him?
And
Were you aware of that?
Yes.
Were you aware of information that
Yeah, there is no
Troopers had an opportunity to
Officer
go and
Connor
speak to
involved.
the
Nope.
defendant?
Yes.
Were you aware but did not know how it happened?
Objection, Your Honor.
I'll allow that.
What did she know?
Yes, I was provided with that information.
I was aware.
Were you provided the information that she had never observed John enter the residence?
I believe that's correct.
Were you aware
report she can
of
amend at any
location
time.
data that was obtained from John O'Keefe's phone?
This is basically his whole case. The stupid judge is letting him lay out his entire case again. This is another opening statement from the prosecutor.
iPhone before you filed your death certificate.
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Are most pedestrian collisions where there's injuries to the lower legs either frontal or rear impacts?
Objection, Your Honor.
I'll allow that.
Oh, no.
I'll allow that.
That's not outside the scope.
Most pedestrian fatalities that we see are with impact with
Your experience?
Objection, Your Honor.
Sustained on that one.
How about a side swipe?
I'm waiting for her to be like, well,
Injury. Is
would
that
it be a
different
fatality?
Relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee.
Now she's finally starting to sustain
Yes.
some of this because she
Side swiping
realizes how stupid she is.
Did you do any type of biomechanical analysis of any alleged collision in this case?
Totally.
No, I did not.
That was about the laceration on the eyelid. The objection was misstates facts and evidence, and it does. That was not the testimony. The testimony about the nose was not about being punched. That was about the laceration on the eyelid.
Did you provide an opinion that it could be consistent with a punch?
No.
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
So Alessi was not allowed to ask these questions. Sustained. She cannot answer. She told you that she could not tell you, so you cannot ask her about a hypothetical. But Brennan gets to go on and on and on about.
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could it
it?
be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand knowledge of how the laceration on the nose happened?
I do not have firsthand knowledge.
Okay, back to the nose.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around?
So now their theory is not only the taillight exploded, cut up his arm, it cut up his nose too. That's the theory, is the shattered taillight is what cut John O'Keefe's nose as well as his arm. This is so stupid.
5:45 p.m. on January 29,
This is
2022.
beyond
I do believe some of that information was
stupid.
was communicated to us, yes.
I just
All right, Mr. Lessie.
Yeah, I bet Alessi's got some questions.
Thank you, Your Honor.
Oh, boy. Did any of that change your mind? You knew a whole bunch of shit.
Dr. Scorti-Bello, this Attorney Brennan just asked you questions about
undetermined.
alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection
In connection with alcohol, too.
of medications?
He gets
I'm going to
objects.
allow it.
He's like,
In connection
nope.
with alcohol, too, you said. right?
Correct, Your
Go right
Honor.
ahead.
He said, correct, Your Honor. The court.
Focus on the fourth item on that list. Can you state what he asked it, correct?
She's just smiling.
And we're going to come back to that in just a moment. But
think
do you
that's outside the
also
scope, but the court's allowing him to
recall
do it. He
testifying
could've done that in
at the grand jury
house.
with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall
He was
what
so excited
your
to talk about
testimony
proton pump
was
inhibitors.
with regard to alcohol consumption?
Well, basically,
But also totality of the.
he's proving right now he takes Pepsid, which is a
Lead to gastric ulcers, and what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them. That would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption?
It's possible.
So it's possible that the ulcers that she said might have come from hypothermia actually might have come from alcohol consumption. And he was taking medication that treats ulcers. So, boy.
Ask you questions.
More, it's just building the doubt, right? It's building the
Before
reasonable
you
doubt.
issued your final findings in this matter.
But the fact that Brennan got to go on and on and on and on and on about different hypotheticals of could this have happened? Could it have been cut by this? Could it have been cut by that? But then Alessi gets cut off completely from it is insane. All right, so now we skip and the jury's gone, and we have another hearing because this is the most frustrating part of today. The prosecution has changed their experts' testimony and their experts' report. Because if we remember, Ian Whiffen testified that at one point in time, John O'Keefe had turned off his phone. He hit the lock button on his phone. Well, this was after the supposed trigger event that the new prosecution's experts had come up with. Well, now, because of that testimony, they have changed the timeline. You cannot do this.
You know, they're going to ask me what's going on. I don't know. I'm real curious about the autopsy and the log. That's some real new information.
I'll hear you, Mr. Lessie.
Thank you, Your Honor.
Your Honor, what the fuck is this log? Oh, Emily just let it play. What the fuck is this log?
The topic I would like to raise with Your Honor is the timing
Stuck on the log.
nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes, that
Okay.
my understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testify
This is
first
so
and
insane.
Dr. Welcher testifies thereafter.
Okay.
So the
This is regarding the Commonwealth experts.
has established in reports right up until, not established, they have stated in the reports of Aperture, particularly the slide presentation of Dr.
Chat, bear with me. I'm going to try to gain this up since he is away from the mic. Just give me 1 second. See if it works.
Dr. Welcher,
There we go.
a trigger called 1162.2 that they have associated in
back
the
to
report
keystroke
of
logging.
Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12:31:38 to 12:31:43. And we have been...
I ran out of room on my notes, and he went right past it, so I'm going to back up because he is talking about information that is coming from the vehicle.
Associated 31:43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the
we're going to find out what his issue is
in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period.
May 8th is a very important date. So they received a new report on May 8th. May 7th, if you guys remember, go all the way back a couple weeks ago when we had the voir dire, God damn, I can't say that word, of the ARCA witnesses where Hank yelled and screamed at him and said they were allowed to testify. Oh, this gets you. The judge said in that hearing, I am going to allow them to testify. They have to have their report turned in by the 7th. They turned their report in on the 7th. On the 8th, They got a new report from the prosecution that changed the time of the event. They have already done cross-examination of witnesses based on the time that they were given in the initial report. And now all of that work is done because the prosecution has decided to change its timeline and its report.
Okay. No, I'm just going to get.
Dude, don't interrupt him while he's talking, man.
Although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess
They received it on the 11th,
states
not the
that he is
8th.
making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12:31:43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12:32:16. And Your Honor.
So notice who is actually helping quite a bit with this. It's Karen Reed. Karen Reed is who he was just talking to. He went over and talked to her. Now, Patty, we were talking yesterday, and I'm just putting that up there, about microphones. Look what I just noticed this. Just notice this right now. Microphone. So not only are the microphones at the podium back here, we had 3 different microphones along the jury rail. Interesting. Okay. That's neat to know. Because of the asshole statement yesterday. We're like, who's that asshole?
12:32:16.
12:32:16.
It is 12:32:16.
Okay, so bear with me here. I'm going to share something else. Look at this. This is Sleuthy's timeline. (12:31:38) time of the alleged collision between John O'Keefe and Karen Reed's vehicle, according to Dr. Welcher at Aperture, based on a trigger event 1162-2. That has now moved. So we have the alleged collision, start of the 36 steps at 12:31:56. John's phone notes Doppler pocket state cleared. John's phone is unlocked by a face. That's 12:32:04. 12:32:06, John reads a text message. Message application goes out of focus, and John's phone is locked for the final time at 12:32:09. At 12:32:16, that's supposedly the end of the 36 steps. And guess what? Guess what now starts at 12:32:16? The Aperture trigger event.
It is 12:32:16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. Right. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12:31:38 to 12:31:43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to...
It is absolutely a Rule 14 violation.
Provide a defense, we have to be able to
oh boy,
to evaluate that information in terms of our entire defense, and it's just not limited to ARCA. It's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that, and I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago.
Right, they had this.
So that is they decided that it needed to match up, even though they've had this information for years. They just decided that it needed to match up. Yes, I did. Let's take a look at this.
Fuck off. This was
Well, all right. It's not very loud. Why is it not very loud? All right. Hopefully you can hear this.
because this is me pissed the fuck off. This was always planned. Hank Brennan thought that ARCA was going to be a
Why is that so low? I can't hear it. Let me find Nerdy Pink Panda on TikTok. Bear with me for a second. Hang on. Sure, I gotta log in. All right. And what was it? It was Nerdy Pink Panda. Nerdy Pink Panda. Okay. All right. Let me see. And it's really low here. Why is it so low? Is it? All right. Is it me? Okay. Maybe it's me. All right.
Are you ready to see me pissed off? Because this is me pissed the fuck off. This was always planned. Hank Brennan never thought that ARCA was going to be allowed to do their rebuttal testing, and this is what he had planned just in case they were. And I can tell you exactly when they decided that they were going to pull this little fucking scheme on.
It says I'm sharing. All right, hang on. I could see it on my thing. Okay, here we go. Try again. Take two.
Are you ready to see me pissed off? Because this is me pissed the fuck off. This was always planned. Hank Brennan never thought that ARCA was going to be allowed to do their rebuttal testing, and this is what he had planned just in case they were. And I can tell you exactly when they decided that they were going to pull this little fucking scheme. On August 29th, Ian Whiffen testified, and then that was the day of the Arc of Wadir. Hank Brennan knew from the moment he had that ex parte communication with Bev that we all clocked that he was going to be testifying. And because Hank Brennan knew that those reports were full of shit and he was about ready to get called out on it in court, that's when he instructed his expert to reevaluate the data. And if that report was sent to you by May 8th, why the fuck did it take you to the May 11th to send it to the defense? Oh, I know why. Because once Yuri Buchanan took the stand and they systematically dismantled your entire fucking corrupt investigation piece by piece, that's when you knew you
I like this person.
you lost the jury. So you sat on on that until May 11th to try and blindside these people. But guess what? They decided to play back at your game. Karen, yeah, she wasn't really sick. Now was she, everybody? I think we can all say because they needed a day to pore over the report and fucking call them out in open court. And like Alessi said in court, there's absolutely no reason that you shouldn't have already had this information. If your expert screwed up, that's on you as a prosecutor. But we all know that it wasn't a screw up. You thought you could get away with it, and ARCA fucked your shit. Are you ready to see me pissed off? Because this is...
I like her. She does not hold back, does she? Holy crap. Wow. And I don't know why I stopped sharing. Okay, let's go back to...
The data from that has been...
Whoa. Sorry. I didn't blow your eardrums out too much. I don't know how loud things are, so...
It's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation.
But what are you asking for?
Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush. If there's
The tech is ambushing me right now, and of course he had to say it 3 times. And the tech, have we been ambushed by the tech? Yes. Oh, let's continue on. Yikes,
Honor,
yikes.
I will do that, of course. And I will also say, without getting in, this is really much different than ARCA.
Option, if that's
before it's the information of Aperture that has been extant before the May 8th date of the report. Thank you.
Right.
Cross-examine, not full, but a significant part of
this is Brennan gets to go up there.
Made, reconcile, or identify
okay.
more closely. It doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to the
This shithead gets up there and tries to say that it's completely fine. It doesn't change any data. You're changing the entire timeline. You have based your case on this timeline. You've let the defense cross witnesses based on this timeline that you are now going to change completely.
disclosures that we believe were wrong.
He's saying it's essentially a rebuttal.
And it's clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. My case in chief, because we now have this available data. As I said, this wasn't ambush. Isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance,
so we screwed up.
Brennan has provided a lot of.
We screwed up. We didn't take this into account. We fixed it now, but like after trial start, in the middle of trial, you can't fucking do that. And Betterow was on one of the podcasts today. I listened to him. He's beside himself.
Information.
And I think EDB is about to go. I did not catch her. I did not catch her freak out, but Patty said she had a freaking meltdown.
He referenced Mr. DeSorbo, who is a defense witness.
Mr. DeSorbo, the defense witness.
Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline. Okay. And he provided that report months ago. Wow. Okay. So as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago. Okay. The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. Okay. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffen's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first.
All right, I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
Time out here. We have doggy dreams. Oh, was that it? Oh, nope. There we go. Doggy dreams. We got the Twitch. Did have some barking there a minute ago. Let's see. Turn the mic here around. No. Just a little. Oh, I guess I didn't name the camera right. That's the doggo cam. Okay. Sorry. I had to interrupt this for doggy dreams.
Yeah, I knew Aperture was, and I thought he may have been something. The name just sounded
Neither
familiar.
Burgess nor Welcher were part of the first trial, but they were retained. Aperture was retained.
We're not going to get an answer to this today.
Cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report.
For a mistrial. Alessi is so for us of time. It is commonly referred to as wibbly wobbly, timey-wimey, and we will accept nothing less. Alessi is...
Layperson's term is a variance of time. Burgess,
Alessi, no. Damn it, Alessi.
Months ago, has a whole section on clock drift. That's not a runner. The last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it, because they're surprised.
It's a fetching reason.
Violations. They were given 5 weeks. We did not get the report until May 7th.
So this guy gets to get back up here.
They estimated they needed 5 weeks, and they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th.
So he gets to get up and just say, the defense has got a violations. The defense has done violations. It's like...
And so we believe we are entitled to have our experts.
So everybody wants more time.
Materials, do his testing, provide opinions. None of that is going to happen anytime soon, because he still has not finished reviewing all the materials. There's many, many gigabytes. He's in a difficult schedule. He is away.
So basically, he's saying, I want to go back because...
Effort and expense has gone into preparing our case for the jury. Proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical.
He was complaining about the stuff that, so he was complaining too about the stuff that ARCA did. Now listen.
The materials. There are entirely new subject areas within this information.
So they hired ARCA because of the Aperture stuff, and ARCA has two different things that they can do. They can give the testimony that they give the first time, the stuff that the FBI contracted them for, okay? And they were hired to rebut Aperture. And rebut sounds like what they did, because while Brennan's got a report and a couple of people that go, this happened and that happened. Listen to what the defense has with ARCA.
The materials. There are entirely new subject areas within this information.
Really?
Well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting.
So because you didn't hire a good enough expert, you're mad because the experts that the defense hired are better than your experts and actually went out and did the work and did demonstrations and experiments and have results from those experiments. So I can't wait for these Aperture people because I think they're going to get ate up. I think they're going to get destroyed on the stand. I do. I think they're going to get destroyed. And so I can't wait.
And then preparing testimony to address the claims made by the defense experts, not themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. Way he's going to be able to testify anytime soon.
Boy.
And have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, if he's had adequate time to prepare. If either of
So he wants the
ARPA witnesses to testify.
just listen to this.
Introduce new opinions, new testing, new demonstrations. He should be able to continue reviewing the materials, actively engage his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the old issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the
In violation of discovery orders. He's trying to say that they're still violating discovery orders, unless he gets on his ass right after this.
Not be cured in any other way. So we ask that he be able to relies on Shannon Burke.
Thank you, Your Honor. I think and I understand that
This is ridiculous. This is so pisses me off.
When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture.
Eating its tail at this point.
ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA.
Yeah, that's what year?
When Dr. Rentschler was on the stand, with Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try.
This is insane coming up. This is absolutely insane. She said in that hearing that she is going to allow the ARCA witnesses to testify. She goes back on that in just a moment.
That there should be ongoing remedies of something that's already been decided, I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to
the prosecution will have to have their experts review it.
Address this matter as if the defense is making perpetual violations. No. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations.
That's not what she said.
My final 2 points.
That's not what she said.
What
she said
Mr. Brennan
would need time
is
to review it.
seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things.
Let's see if I can
have ARCA have to come on.
We couldn't hear him earlier, and now we can hear him too much.
Aperture come back and essentially have almost a rebuttal to a rebuttal as of right.
Right.
I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal,
2 bites at the apple, right?
Surrebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give Aperture more time. And I haven't even heard a deadline yet for Dr. Welcher.
Oh, no, they didn't.
It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude
It's Bev's courtroom, so she'll make up whatever she wants.
its review of the ARCA work, and that there be a reflection.
And if she is still leaving open the possibility that she's not going to let the ARCA witnesses testify after they've put all of this expense and done all of this work, and if she comes back and says, nah, I've decided now that they can't testify, that will be the most insane thing. I mean, I who knows? It could freaking happen.
That the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
So I have a question for you, Mr. Leslie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
Week and a half.
That's our best estimate still.
Week and a half.
And
She's got the.
you do this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay.
That makes sense.
All right. I needed all this information now, so I appreciate it. All right. Thank you.
All right. Watch Hank. Watch Hank at the end here.
Final decision, Your Honor, but
He's mad because he didn't think. I think the panda lady is right. That this is all ambush. This is all completely planned by the freaking prosecution to sabotage the defense, because he knows if ARCA gets in, he was going to change that thing. He knows that timing's off. He know it needed to be changed. They talked about it, I'm sure. They all got together and conspired and said, "Oh, this is messed up. We got to change this." What a freaking mess. So at the end here.
Okay.
That makes sense.
All right. I needed all this information now, so I appreciate it. All right. Thank you.
All right, let's go back to normal speed because I do have it on 1.5 speed. Watch how aggressively that laptop gets closed.
So I appreciate it.
He's throwing a little tantrum.
All right.
He's all mad. He's mad.
Need the extreme OnlyFan close up today. I don't know. Emotions are high. Everybody. Early, well, the attorneys went back on the record to fight more over the experts.
All right, I want to see this here.
Is going to happen with the experts. And when Alessi started, it was regarding the Commonwealth's experts dropping a new report. That was the first issue. What's going on with the Commonwealth's experts and a new report that the Commonwealth says was turned over May 9th. The defense said they got it May 11th. That was the first issue.
Yeah, I mean, even they can't even agree on the dates that they turn shit over to each other.
Well, we're talking about experts, and can we talk about issues with experts without talking about ARCA? We're at bravo levels of drama in the courtroom talking about who will testify, when, what, and how. And we did hear Alessi say at one point, ambush has been leveled against us. But what is happening with the Commonwealth? And the Commonwealth said not to level more disparities, but this is what's going on. And can ARCA be allowed to testify to all of their new stuff? And can't the Commonwealth split their expert is essentially what they were asking for, and to allow their expert more time to review all the new discovery from ARCA, which the court previously said the Commonwealth will be allowed time to let their expert review ARCA information. So let's start with ARCA first, and even though it was the second issue addressed, and then we will just jump back because time is wibbly wobbly and clocks lie. So with the ARCA issue, that was the second thing that the court testifying.
All right.
And the court had said one of the things with ARCA getting information is because ARCA needed to rebut what the new experts for the Commonwealth had to say. Aperture. Yes. Are ARCA and Aperture too close to? Yes. The Commonwealth experts are Aperture, the defense experts are ARCA, and everyone's going like this. So the defense is arguing you can't let them split their testimony. They essentially are shifting the burden. That was the defense's argument. Your Honor, this is prejudicial to the defense. It is unfair. ARCA can't have Aperture's new rebuttal information to review so they can testify about it. So we are now in a complete circle of, well, we're just responding to them.
Yep.
Brennan again raised the fact that the court was allowing the late discovery from ARCA to come in and saying, Your Honor, we keep saying this is late discovery. They dropped a ton of late discovery on it. The court found a discovery violation as to the defense with regard to that, but said that the remedy was going to be to turn it over by May 7th. And
I don't see how the prosecution turns stuff over late, and it's the defense that gets the discovery violation because they deleted text messages
to allow for a
God,
voir dire.
it's
Did
so
Brennan use his
freaking
voir dire
ridiculous.
to ask about new opinions, new testing, and what ARCA was doing? No. He asked about signal chats and who had lunch with whom. That's what he asked about. Now, at the end, the court did cut him off at the end of his voir dire and was like, you're done. So he didn't even start down that path. So
he did almost 2 hours with
time. But ARCA
with
wasn't done
Dr.
with their
Wolf
reports at the time that he did that voir dire. So the voir dire went into more communications than into determinations. So we are now in like a blue screen boot loop of whose experts are going to testify to what and how. So with regard to ARCA, the defense does not like the prosecution's suggestion that their expert testify, then ARCA testify, then their expert gets to go again. Because then the defense is like, well, if ARCA hasn't seen all their results, they can't address them. This is why there are discovery deadlines. So May 8th. If I previously said May 9th, I was incorrect. May 8th, the day after all the ARCA stuff came in, May 8th. But they say they did not get it until May 11th. The issue with that is that they are using those timing reports or the impact logs that are numbered. And those logs, they are corresponding to a time this testimony got that he was struck between 12:31:38 and 12:30.
I probably didn't find the real freak out here, so.
Wibbly wobbly, timey wimey. No, we didn't. No one said wibbly wobbly, timey wimey except for me because they are very serious and they are in court. But God, today was a lot. So Brennan got up and said, but Your Honor, this isn't new information. I said in my opening that there were different clocks and the clocks were wrong. The clock on Waze versus the clock on the cell phone versus the clock on the Lexus, the clocks are wrong. And our expert, Aperture, reviewed their expert, who the closed captioning just calling Mr. Disorder, and I think that is hilarious, but I think it's Mr. Disorba. Brian Sorbo, I don't know. I'm going with Mr. Disorder because that's what closed captioning just kept saying, and I think the court at one point actually said, continuance, we need more time. What would a continuance look like? It was that.
All right. I'm really curious to see what she decides.
Commonwealth is in a pickle as to ARCA. They do have a lot of information that their expert needs to review. There are reciprocal discovery deadlines for a reason, but the Commonwealth is going to have to sort it out. The court might give them a little more time. That's a different issue. The new report, when the defense has already cross-examined numerous witnesses on the timeline that the Commonwealth has provided, is a issue for the defense that is at the Commonwealth's hands. And I think the easiest result for the court is to exclude it. We'll see what the court decides to do with that. I don't.
What an insane day. Brennan just keeps kicking his own ass, it seems. He keeps yelling at his own witnesses. He gets this really harsh tone with them. Then he comes in here and says that, the defense made discovery violations according to you, so we just that throws out all the rules. Somebody said something the other day. I just remembered it, and I don't remember what I was listening to. But they're like, what is this court? What is going on in this court? What rules does this court actually go by? And somebody hit the nail on the head perfectly. This court is Calvin Ball. Judge and Brennan, not so much the defense, but the judge and Brennan are playing Calvin Ball. If you don't know what Calvin Ball is, look it up. Calvin Ball is from Calvin and Hobbes. I say look it up and then I go into the explanation. Calvin and Hobbes, the comic by Bill Watterson, was one of my favorite comics forever. And I was sad the day that it ended. I'm somewhere around here, I'm sure I have got most of Calvin and Hobbes books. As soon as a new book came out, I would get it. I loved Calvin and Hobbes. Calvin Ball is the game that Calvin and Hobbes played with each other. What are the rules of Calvin Ball? They can be made up at any time. There are really no rules except for the rules that are made up whenever the rule needs to be made up. That is Calvin Ball. That is also this courtroom. That is also this judge and this prosecutor. That is what they're playing. Yes, there is no spoon. Oh my God. The snowmen. Oh my God, the snowmen that Calvin and Hobbes used, or that Calvin used to make. His dad would look out and there'd be like, these just terrible looking snowmen, like, zombie looking creatures or whatever. It was so awesome. So, all right. 2.5 hours. I'm hungry. I think we're going to make some food here. We're going to make some food here. Can't tell. All right. Well, let's see what tomorrow brings. We will probably have a decision early in the morning. I will not be up at the beginning of court, but I will catch it as soon as I get out of bed. And we'll see how this amazing case continues on. And yes, we'll be at the shop tomorrow. We should have Michael and Jody. Everybody will be back. So we'll go over kind of probably won't be as in-depth a show tomorrow night as far as the case goes, because, we got Jody and Michael. So we'll see if something crazy happens tomorrow. We'll definitely go over it. We'll definitely go over the day, and then we'll talk about what other things we talk about. So, all right. Well, you guys have a wonderful night. Thank you. Oh, you know what? I have one more video that I can see if this plays. All right. So this is Agent Gray. And then I'm just going to keep swapping these out. I'll just play them in a rotation. So enjoy the outro. This is just a little short introducing one of the other agents from the show that I'm eventually going to complete. I promise. I will be actually, the other day, I got quite a bit of editing done on one scene and it's almost done. So then I can move on to another scene and I'm pretty close. So I need to set a date. That's what I was talking to a person the other day that I'm very close to and that I really appreciate. That is a wealth of great advice and information. And so I always love our conversations. And you should set a date. Set a date and then stick to that date. So I'm going to set a date. I don't know. I'm going to set a date. Now, I tell you, I put it off. Now, my date might be I'll set a date tomorrow because I am also the king of procrastination because I am Gen X. And that's all we do is procrastinate. But I am going to set a date for the show to be released. I just don't know what that date's going to be yet. But I will take this weekend to look at where I'm at as far as editing goes, figure out how much more editing I really have to do, and then we're going to set a date, and then I'll announce that date. So, all right. Outro, Agent Gray. We will see you tomorrow.
Introducing Agent William Gray from the Bureau Undermining Misinformation. When it comes to misinformation, Agent Gray knows what's at stake.
We're the tip of the spear when it comes to protecting American democracy. We're the front line of defense against those who would see our country crumble.
Agent Gray appreciates the opportunity he has to make a difference in the fight against dangerous misinformation.
I was a high school teacher for 15 years. Every year I just got more and more miserable. My buddy told me about this new federal agency that was just starting up. I thought that maybe I was the kind of person that this agency could use. And what I would tell you is that I have been seeing what my students post online since before Facebook was cringe. Slurs that they use in Call of Duty chat rooms.
Agent William Gray, a dedicated warrior against misinformation.
Our mission is to protect our country's important institutions, but we can't do it alone. We need help from people